I'd like to introduce Rachel Johnson Greer, who will be speaking on the topic of the cost of private label sellers ignoring product compliance responsibilities on Amazon. Rachel envisions a world where only safe, compliant products are being sold. Focusing on compliance for the largest Amazon retailer in the world has given Rachel a unique perspective on safety. This perspective has brought forth the drive to really get the message out that safety matters and how to manage product policy and product safety performance issues on Amazon. Until recently, there was nowhere one could go to obtain a degree or just a structured learning about compliance. The only way to gain knowledge was to have the experience, and the one expert in the Amazon product development space who truly has that experience is Rachel. Today, Rachel is the founder and managing partner of Cascadia Seller Solutions. Please join me in welcoming Rachel Johnson Greer.
Thank you, James, so much for that introduction. Wonderful to be here at the virtual Prosper Show. It's so wonderful to still be able to share information with the community, to be able to congregate, even if virtually and online, and I'm looking forward to answering your questions at the end of the presentation. What I'm going to be talking about today is the case of Bulgar v. Amazon and what the cost is for private label sellers who ignore their compliance obligations, both for them and potentially Amazon, and what's happening now. So back in 2015, one of the things that was kind of interesting when I first started consulting is that it was super, super easy to get started on Amazon. You'd sign up with a well-known online marketer who told you that you could do this new hot thing called Amazon selling, and you could use FBA, and it was super easy, and you just sign up in 5 minutes tops on Amazon and Alibaba, get some BSR research, and go buy some stuff. You would then airship it to the US, put it up on Amazon, no additional proof of safety, nothing at all, and sell to consumers. And if you're sued, easy. You just shut down your company and start again. There was no evaluation of the product needed, no insurance required, no consumer protection whatsoever. And starting in 2015, they started enforcing on product performance, but they still weren't checking any sort of product compliance or product safety. Now, if you're getting started in 2020, you need to do a lot more. First, the sign-up process is quite a bit more onerous than it was in 2015. You need to have a business bank account, set up a utility, register with Amazon. It's usually somewhere between 30 minutes to even more, depending on if everything goes well and you have everything at the time that you start, including Amazon's interviewer postcard. They've been doing different things this year depending on when you sign up. While you can still order on Alibaba, often that kind of invoice won't be accepted as Amazon has very specific paperwork requirements now. And then sometimes there are restricted subcategories. If you receive a complaint from a consumer, once you finally get everything up and running, you now have to prove that you bought the items new or that they're authentic. And even then, even with all of this change between 2015 and 2020, there is still a gap between when the item is listed, if the paperwork is good, and when there's a customer complaint. So you can still have this gap of product safety and product compliance. So in the potential future state with Amazon, if you are trying to think about, okay, how is this going to work for my business going forward, you would have the same setup. I don't think that they're likely to change that now that they've started asking for the business bank account, et cetera. But what I do expect is that eventually they're going to start asking for your insurance information up front rather than waiting. And right now they don't even ask for it. They just say to get it once you hit 10,000 in sales. Then you would want to make sure that you have plenty of coverage for product liability insurance, not just general liability insurance, and make sure that you can provide product safety certificates and commercial invoices for import documents if that's applicable for your product. Then you submit all your documents to Amazon via case, wait for your review to be complete, and then if you receive a complaint, you not only need to provide proof of insurance coverage, but also fixing the issue. This is what I expect to be a potential future state, depending on the outcome of Bulgar v. Amazon. So, what are we looking at? Until recently, Amazon has been protected from product liability lawsuits from customers due to being a marketplace facilitator. That's a specific term that's basically, according to the contract, they don't have any expectation of need for coverage of liability because there isn't any sort of concern around ownership of the product, as in the product is owned by the seller and it's not owned by anyone else. And so even though Amazon is the marketplace, they aren't responsible for whatever happens with that product, essentially is the idea. Now with Bulgar v. Amazon, the situation is basically that Andrea Bulgar bought a replacement laptop computer and bought that on Amazon, of course. The listing identified the seller's eLife from Linoge Technology, otherwise known as Linoge, in the paperwork. Amazon charged Bulger for the purchase, retrieved the laptop battery from its location in Amazon warehouse, prepared the battery for shipment in Amazon branded packaging, and sent it to Bulger. Now, anyone who's sold on Amazon is very familiar with this. They were obviously using FBA, and so Amazon employees picked and packed it, and it shipped out in an Amazon box. So, part two, the product fails and the customer sues. She alleged that the battery exploded several months later, and she suffered severe burns as a result. The problem was that when she sued Linoge for the situation for strict products liability, negligent product liability, breach of implied warranty, breach of express warranty, negligent undertaking, it's a lot. But all of those legal terms basically say that when a product is sold, there is an expectation that it will not explode and burn you. The problem was that Linoge was not a company that existed as such in the US. It was a Chinese shell company. So the problem for her, for Anne-Greer Bulger, was that Amazon won based on the marketplace facilitator doctrine. Essentially, that Linoge lost by default because, again, it was a shell company. It wasn't actually a real company in the US. They just had filled out paperwork and called it good. So obviously, that meant that there was nobody for her to sue because they didn't have any assets here. There was no one to cover her hospital bills. That's the most common reason people sue in the US, is to cover hospital bills, unfortunately. So the court in that case said that because Amazon did not distribute, manufacture, or sell the product, that they were not responsible for it, and Amazon won. So she appealed and she went to the appeals court, and she said that Amazon was strictly liable because the situation was as such that because it was shipped in Amazon branded packaging, that it was shipped by Amazon, that there is an expectation of trust that comes from that, and that according to the established principles of strict liability, Amazon should be held liable if a product sold through its website turns out to be defective. In the case of the appeals court, they actually entered in opposition to Amazon and in favor of Andrea Bulger, and said basically that strict liability, quote, affords maximum protection to the injured plaintiff and works no injustice to the defendants, for they can adjust the cost of such protection between them in the course of their continuing business relationship. That's a very long and wordy way of saying that Amazon can just raise its fees to cover the cost of this kind of strict liability for their website. They can increase the fees, they can change the business relationship, that there is nothing unjust about holding Amazon responsible in this situation because they can afford it. That's basically the idea. Now, Amazon has just appealed very recently, I believe last month, and their main case is that first, can a marketplace provider be held strictly liable? That's their main thing that they've been saying for a long time. And second, is it really the place of the courts to decide this when the legislature has been discussing options here as well? Now, who knows what exactly will happen here, but these are the cases that Amazon is making. First, that they're still a marketplace facilitator, they're still sticking with that doctrine. And second, that it's not really the place of the courts to make this decision. And many of us know that just because it's not the place of the courts, according to the people who are arguing it in front of them, according to the lawyers, the courts have made lots of decisions without having legislative backup. So just because that's the case doesn't mean it's actually going to happen. So the last stage of this will be at some point in the next 1 to 3 years. Amazon is currently appealing to the California Supreme Court. According to Horvitz and Levy, this takes an average of 2 years, depending on the case, with a low of 1 year. And usually the appellate process ends with California Supreme Court decision. And that's true both when the court says, nope, no dice, you don't get to move forward, or when they write an opinion after a briefing and an argument. Sometimes things that are based on federal statute will go to the Supreme Court, but it's not necessary to go there. And the thing that's quite interesting is that less than 5% of cases that are appealed even go to the California Supreme Court. And of those that end up making it there, less than 5% of those end up making it to the Supreme Court. So there's not a lot of indication as to where this will go, but we certainly won't know for another year or two. So if Amazon's loss in the appeals court were to be upheld, then they will be held strictly liable for anything sold on the website and shipped in their own packaging. This could make the whole process very tricky for FBA. So this is still in appeals, so why should sellers care right now? By establishing a precedent of strict liability for Amazon, this could force Amazon to drastically change its business model, particularly in light of the situation with FBA. So if something is managed by Amazon, touched by Amazon, shipped out by Amazon in an Amazon box, they may be held to a higher standard than if they are just a strict marketplace facilitator, having things be shipped and sold by a third-party seller in their branded or unbranded box. So it may be that participation in FBA has a higher threshold of review in future. We're not sure yet. If you are concerned about the likelihood of liability when it comes to the shipping of your products and Amazon reviewing them, then what I would suggest is making sure that you have a backup 3PL and you're not completely dependent on FBA. That seems to be the crux of where the case went, that because it was shipped from Amazon in an Amazon box and touched by Amazon employees, that then made it to where Amazon could have known of a problem. Now, when it comes to laptop batteries, I would say that probably Amazon couldn't have known, but there are plenty of situations that have been held in previous product liability and product safety cases where if the retailer in some way touched or moved the product or put it out on the shelf, or an employee in some way held or touched the product, that they could be held liable, therefore, because they had a physical engagement with the product. So we'll see what comes out of this, but I would expect that there would be a significant change to FBA. And the most particular concern that I have here is that the court feels that there's no issue with Amazon raising prices or increasing costs to justify this. So one of the things that Amazon mentioned in their appeal was that this could be just solved with the legislature. And what they were referring to is that there was a bit of legislation going through California this year, and it was called AB 3262. And it isn't moving forward in its current form, but it was being discussed in committee. And basically, it seeks to hold electronic retail marketplaces to the same liability standards that brick and mortar is held to. That would be a huge blow to a lot of online marketplace facilitators because they are able to offer massive selection and allow smaller businesses to get onto their platforms because they don't have those liability issues to deal with. It's quite expensive to defend yourself from quite a lot of lawsuits. It's definitely not cheap. Insurance costs will go up. Amazon actually supports this legislation as long as it's applied to everyone and not just to Amazon. And a lot of people are actually annoyed about this. Like Etsy's CEO actually penned a whole letter about this situation, basically saying that if this is actually passed, that Amazon will be in the best position moving forward because they have the deepest pockets and can afford to cover the expectations and costs of strict liability. So this could be quite an interesting thing going forward because whither California goes, thither goes everyone else. Was basically the idea that as soon as you start having a situation happen with California, everyone else has to solve the problem as well. So what is normally required with a brick and mortar? We've been talking a little bit about the kind of situation that Amazon might be facing where they're held to the same standards as a brick and mortar store. What might that look like? Well, the first thing is that everyone needs to have general liability insurance. That's pretty basic. Additionally, you need to have some sort of product liability insurance or a product liability rider, typically $1 million for typical products and $2 million for higher risk products. Amazon has actually defined what those are previously to their Vendor Central users, where items like products for babies or brakes in automotive or something that's for outdoor sports use. There's a few different things that they have on that list, and those are all things that require extra insurance. And then you also need to have some sort of what's called due care documents. And due care has this very interesting legal concept that's kind of fuzzy. That's basically what is the care that a reasonable person would take when doing this work. It's kind of a funny concept where it's kind of up to the interpretation of a jury or a judge as to what due care might be. But what has been found in previous court cases is that product testing, some sort of consultation on design, and some sort of properly tracked import filings, and you need to keep your paperwork for at least 6 years, that is considered to be due care. And is this required for everyone? No, not really. A manufacturer can exert the most control over their supply chain, while a influencer or an advertiser, such as a blogger, exerts the least control. So that generally means that the advertiser, and this traditionally in court cases has been like a newspaper, wouldn't be considered responsible. Private labelers and importers are usually considered the same as a manufacturer for legal purposes. And so for the purposes of liability, they would be held the same. Brick and mortar retailers have limited liability concerns to manage when there is no private labeler, manufacturer, or importer to sue, such as when they went out of business. So Simplicity Cribs had a bunch of problems with drop side cribs. They went out of business due to the lawsuits. And so when I was at Amazon 10 years ago managing this, we actually had to do all the filings to the US government and to handle all the refunds ourselves because Simplicity was out of business. And so as the retailer, we were responsible. That was with Amazon.com selling the Simplicity Cribs. Or they aren't in the US at all, as in the case of Linoge. And that was the situation with Bulgur v. Amazon, that because Linoge was basically a shell company that had nothing to sue and didn't have any insurance to speak of, that there was no recourse for the consumer except to sue the retailer. And Amazon has never considered themselves a retailer, so this should be very interesting to see where this goes. All right, so where might Amazon go now? Let's dig into some examples of how Amazon is handling compliance in the past month in Amazon UK and US. This is very interesting because it really has been that recent, just in the last month. This is something they sent to amazon.co.uk. They asked for written evidence that the product that you are selling has been authorized for import into the EEA, which is the European Economic Community, essentially. It includes Switzerland, Norway, and the other small countries in Europe that aren't part of the EU. And they're asking for invoices, import documents, authorization letters, basically whatever they can to prove that the items are authorized for import into the EU, into Europe, excuse me. And the reason for this is because there's been so much junk imported into Europe that is not compliant for sale in Europe. They have different electrical systems. They've got different regulations around product safety and toy safety, and items keep being imported that are not legal for sale in Europe. And so now they're trying to enforce that. Literally just in the last month, we saw this. We also have seen a bunch of these come in from Amazon.com, and we've actually gotten quite a few inquiries just this week, as Amazon appears to be notifying people that they're going to start removing items or destroying them starting on the 19th of October. And what the context was here from a Facebook post was product compliance requests. And if you sell anything that could be regulated, according to how they're doing it right now, it looks like they're primarily focused on children's products right now. And in this case, they had 89 requests from Amazon on certificates, and they're asking for what's called a children's product certificate or a general certificate of conformity. And these need to be in a very particular format and need to list out exactly which laws they apply to. It's a very basic format, but if you don't have it exactly right, your certificate will be rejected. It's super fun. And here was another response to that original poster. I saw it too. I did not get an email with a request for documentation. We dug into this and found that Amazon notified vendors of the issue and did not notify sellers. Whoops. So the listing can be at risk of removal and your product at risk of destruction. So in this case, there was a complaint about bundles. And if you bundle something, you actually need to create a whole new certificate because you are now repackaging that. So it's quite an interesting approach here. But we have been able to get Amazon to accept these, but it's a bit more paperwork heavy. And then another person here said they want a selling application for product safety and the children's product certificate. Anything discontinued by the manufacturer is going to be tricky because you need to make sure that it's been tested within the last 3 years. They won't accept anything that is newer than that. So it's kind of a very interesting situation where a lot of people didn't expect this, even though it's required legally. And they're just not used to this whole process of actually having to comply with product safety regulations. All right, so what now is to be done if you are a seller? If you need to make sure that you are getting all the paperwork together and you get some sort of comply now notice from Amazon, what do you exactly do to make sure that you are compliant? Okay, so the first step for you to determine your existing liability is to know what exactly your designation is as a company. Are you considered a private labeler, importer, or manufacturer, or are you a private labeler, wholesale, or retailer? And you might be wondering, why is private label on there twice? And it's because depending on what kind of private label you're doing, there's different kinds of liability. So if you are private labeling a children's product in the US, so you're not importing it, you're not the manufacturer, you're private labeling a children's product here, then you can be held jointly liable for that product. So if you're doing, say, children's pajamas, for example, the manufacturer is liable, but so are you. You are jointly liable. Now, if you are doing something like cosmetics or skincare or almost anything else, actually, other than CPSIA, the Consumer Product Safety Improvement Act, anything that's regulated by that, you're jointly liable. When it comes to just about anything else, then you're actually off the hook. And your manufacturer is primarily liable for whatever happens. There's a reason why when we talk to some folks who are like, I've talked to a whole bunch of different manufacturers here, and they just won't respond to me. They won't do anything. It's like, yeah, because the cost of making your product is far more than the cost of insuring themselves for your product. And so they're just not going to take that risk. Now, you may be willing to take that risk and import from a company in China, but just be aware that if a US manufacturer isn't comfortable taking that risk, then maybe you should be talking to your insurance company and your legal counsel to make sure that you're comfortable with taking that risk as well. So the way that you decide is if you buy directly from a manufacturer in the US in certain categories, like I said with the children's items, if you buy from overseas and import using your own customs bond, if somebody else imports using their customs bond or you work with a company to do it, then they are strictly liable. So if you are a company that does imports for other companies and you're importing their stuff on your customs bond, so say you're facilitating a seller based out of India or Pakistan and you're bringing it into the US with your own customs bond, you're the one who can be sued for bringing that product into the US. Or if you make your own products in-house, including the labeling of the package. So if you are bundling something and putting it in a new package, you are strictly liable for making sure that the labeling is correct and for making sure that none of the warning labels that are required have been stripped or have been removed. So I see this happen sometimes with people who are making bundles and they don't have the right paperwork involved. And then it's, anyone who is the other kind of private labeler, or if you have like a reseller permit, you're buying wholesale, or if you're buying liquidation or retailer, and then certain categories of manufacturer. All right, so what happens when you don't manage production? You end up getting these kind of messages such as used sold as new or inauthentic. People make complaints and Amazon comes up with the most appropriate response to it that they think is appropriate. And then now you've got to solve that problem and provide some sort of proof that you had an inspection or that you test to make sure that everything is new or that you had the paperwork to show that you don't sell used products. It can be pretty frustrating working on these kind of responses. The preventive measures that you can take to prepare yourself so that you can respond to those issues, because they do happen, sometimes due to customers being confused, sometimes due to competitors pushing on you. The things that you can do to prepare are product testing. That's taking your product to a lab. That also can include doing it at a production level, doing it at a sample level. For a lot of certificates, you actually have to test a production sample. You can't just have the sample sent for testing, you actually have to have a production sample. So that's a bit tricky. So make sure you know which one you need to do. Product inspections are what most sellers are familiar with, where you send in an inspection company to look at the shipment before it goes out and make sure that it doesn't have any issues with it. Tricky bit there is that standard inspections are actually less strict than what Amazon expects in terms of their negative customer experience rate. So sometimes you might have a past inspection and Amazon's still not happy with you. If you can, try to buy certified products that are certified already. Something that is off the shelf if you're doing private label and you're just starting out, buy something that's already been designed and then remarket it for yourself with your own brand, but already having been certified. That's going to be a little bit less stressful or frustrating for you. And then you can also do factory audits or review their prior factory audits. So you can show yourself, okay, so these people can actually do good work. They can produce to spec. They will follow the rules, as opposed to maybe a smaller factory that can get you a better price, but maybe will source from a cheaper supplier. And maybe now you have leaded paint in your children's product. So when we're thinking about what you can get here, product testing is a specific product versus a shipment or design, whereas inspections are a shipment. And for the rest of this, it's really about knowing what your requirements are and what your expectations are. But make sure that you know what you're getting in a test versus an inspection. And then much less common are the certification versus auditing, where the certification is evaluating the design of the product and the flaws and issues that may happen for safety. The tricky bit here is that a product can be perfectly safe and certified for safety, and still get taken down by Amazon for quality. Very frustrating when a safe product gets taken down for quality. And then for the audit, it's really about making sure that this is the right kind of company that you want to work with. And we just saw a warning come through just 2 weeks ago where Amazon asked for proof that the company that the business was sourcing from was socially compliant, that they were not using slave labor or underage labor or other kinds of unfair business practices. And it was the first time I'd ever seen Amazon actually ask about that. Okay, so going forward in years to come, how can you make sure that you're prepared for what you need to do, to grow your business, and to be prepared for any changes that Amazon makes? Evaluate your risk, know what you're facing. Make sure that you have a solid paperwork storage system. I know this is like the most boring thing you can think of, but make sure you've got good paperwork storage in place. Get insurance, don't wait. Make sure that you have insurance in place. I know there's some other speakers talking about insurance. There's some really great insurance providers. Don't wait. Check out what your options are. Make sure that you're protecting yourself. Perform mock audits of your paperwork and your systems with qualified third parties, such as many of the companies that do performance and review around here, including ours. Will go through your paperwork and we'll pretend like, what happens if you get a used sold as new complaint? What happens if you get a product safety complaint? Let's fill out the spreadsheet. Let's see what Amazon would look for and see what you're missing. And then track all of your customer complaints. Make sure that you know exactly what's going on, follow up with the customer, try to figure out what's going on, because you not only have an obligation to do that for Amazon, and they'll expect that when you're responding to an issue, but you also have a legal obligation to do that if you are one of those private labelers that's required, or a manufacturer importer. There's actually a legal requirement to track customer complaints in the US. So if you have any questions, please hang tight and we will be answering them shortly. And if you would like to email info@thinkcascadia.com.
Thank you, Rachel. Thank you so much for everything that you do for all of the sellers out there. You not only have some great stories to tell, but you also have a great story on how you got here. I want to thank everyone who is attending and remind you that if you look at the Q&A box at the bottom of the Zoom screen, you can submit questions. I do have one to begin with. What lab would you recommend to work with that Amazon will actually accept?
Great question. So the labs that I usually recommend for Amazon sellers are the smaller labs, not the bigger labs. So the bigger labs would be something like Bureau Veritas or SGS or UL or something like that. The problem is that when they're that big, they don't really like to deal with small companies. Even when I first started working at Amazon, we were too small for them. They didn't even want to work with us. And so if you only have a couple of items to test, I recommend working with a company like Modern Testing Services. Their website is MTS Global. You can also find labs to work with in the supplier directory on Seller Central. And so pretty much all the labs have worked on getting their account set up and making sure that they're on there. But I'm a huge fan of MTS and think that they do a great job.
Okay, wonderful. I have another question here. Amazon requested certificates last month, and they still haven't accepted what I sent in, even though the lab prepared the certificate for me. What can I do?
Yeah, this is a really, really common problem. And I can't tell you how many times we've had people come to us and say, my certificate follows all the rules. I've done everything that I needed to. Like, what's wrong with this? Amazon's so stupid. That's usually the expectation, is that Amazon's just being dumb. But actually, it's because Amazon has a very specific checklist to follow. They're literally like click, 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 click to make sure that the checklist is being followed on their end. And so what usually we find is the problem is that the list of tests that are there aren't specifically listed out, like the exact tests that were done. There's
Sure.
also sometimes missing content. So we actually have a process where we create our own certificate, and it's the most boring format possible, but Amazon usually accepts it.
That's great to know. I have another question here. We have some European games that only have European standards, not ASTM. Will Amazon take them? I hear they're a little bit stricter than US CPCs and ASTM.
Yeah, so this comes back to my last answer where it's actually line item testing. So in the case of heavy metals testing or sharp points or sharp edges, you can actually list out what tests have been done because testing to EN71 or something like that actually does have basic equivalencies with the ASTM testing, and you as the importer can actually certify that. So what Amazon is asking for is actually a certificate. They're not even asking for the actual test report. So if you can actually go through and see like line item by line item, okay, I have this test, I have this test, I have this test, this one was done, that one was done, then you can actually issue a certificate based on having European testing. There are a few exceptions to that typically Europe is stricter than the US, and typically European standards are stricter than ASTM standards, but there are a few exceptions, especially around clothing flammability. So be careful around that one.
Oh, yes, that sounds disturbing. And along those lines, how do I figure out what ways customers could damage my products? Am I responsible if they misuse my product?
Yeah, it's this interesting kind of concept between um, intentional misuse and unintentional misuse. Kind of an interesting concept there because basically, if you accidentally misuse a product in such a way that it looked normal and then you get hurt, then it's actually on the manufacturer. It's their fault. But if you intentionally misuse a product, then it's your fault. So, for example, if you had a laptop battery that he overheated and exploded and lit a fire in your kitchen, then that was reasonable that you plugged it in and used it because that's the true function of the product. But say you used that laptop battery to bash somebody over the head and they had to go to the hospital, that is not typical use of a
Yeah.
laptop battery. So that's not something that a manufacturer can be held liable for. So it's really about what can you think of that would be a potential misuse. My favorite example of this is some company that did like a Disney castle thingy on the front of a tricycle for a small child. I mean, it's a castle, it's got points. It's like points. Of course, a small child is going to trip and fall on it and then get
Uh-huh.
poked. So that's something where it's a really obvious unintentional misuse where some toddler is going to trip over it and hurt themselves. And they did. That's why it got recalled.
Well, thank you again so much, Rachel. You've given so much information for all the sellers. That's all the time we have for questions. I want to again thank you. And of course, thanks to all the attendees. We really appreciate that you've taken the time. I just wanted to let you know that we do have more sessions coming up and our closing keynote is at 4 p.m. Thanks again for attending, Prosper. And thanks, Rachel. We'll see you again. Thank you.